Hi, my name's Emma Patterson. I'm the Principal Solicitor at Patterson Law. I'm going to do a short video about Section 172 of the Road Traffic Act 1988, which is the power of the police to compel people to provide information as to the identity of the driver at the time of an alleged offence. Okay, so you can see Section 172, duty to give information as to the identity of the driver in certain circumstances, and then you get a list of all the different sections that it applies to. Basically, Section 172 is the way in which the police will often obtain identification evidence as to who was driving at the time of an alleged offence. With modern policing, lots of motorists will commit motoring offences without being physically pulled over, which often means that there's an absence of identification evidence. So this little sledgehammer of a piece of legislation gives the police the power to compel people to provide that element of the offence. And the prosecution have to prove every element of the offence beyond reasonable doubt. So, for example, in a speeding matter, it would be the identity of the driver and that that person drove a motor vehicle on a road or in a public place at a speed exceeding the limit for that road. And in order to convict somebody, they would have to prove each of those elements beyond reasonable doubt. And when they obtain the confession effectively in the response to one of these Section 172 forms, they use that particular piece of evidence to prove the identity of the driver. Obviously, if you're physically pulled over at the time, there's no need to send one of these notices out. So Section 172 can be sent to anybody. If you have a look at subsection 2, if it's sent to the person keeping the vehicle, and that can be the day-to-day keeper or the registered keeper, then that person must give information as to the identity of the driver, as they may be required to give on or behalf of the Chief Officer of Police. It's a little aside, but we've had some notices that have been sent out by police officers taking it upon themselves to send them out rather than the Safety Camera Partnership, and on occasions we've been able to show that that particular officer didn't have the necessary authorization, but that's unusual, and that's something you need to speak to us about if you have a concern. And it goes on to state under subsection 2b that any other person shall be required, as stated above, to give any information which is within his power to give and may lead to the identity of the driver. So if you're the keeper or the registered keeper, then there's a burden to name the driver. Any other person, so not the day-to-day keeper or the registered keeper, and there's arguments over the difference between registered keepers and day-to-day keepers, but that's a case called Mahindra, which I won't go into here, it's complicated. But any other person that sent one of these notices is required to give information that's within their power to give that may lead to the identity of the driver. So it's a slightly different burden of proof if you're not the registered keeper, or a burden on you if you're not the registered keeper or the day-to-day keeper of the vehicle. And then it's an offence if you fail to comply with those requirements. But this is an important section. This is what's known as the reasonable diligence defence. Okay, so Section 172 subsection 4 states that a person shall not be guilty of an offence if they can show that they did not know and could not with reasonable diligence have ascertained who the driver of the vehicle was. So that's otherwise known as a reasonable diligence argument, and that's where the person who is the keeper or the day-to-day keeper can't name the driver and then argues effectively that they've done their best to work it out. Now, it's a statutory defence, which means that the burden of proof is on the defendant. So if you're accused of this offence, the burden is on you to establish on the balance of probabilities that it's more likely than not that you've done your best. So balance of probabilities means making the court 51% or more sure that you've exercised reasonable diligence, which roughly translates as doing your best. It's different for somebody who is any other person. They don't have to establish reasonable diligence, so any other person must give information that's within their power to give that may lead to the identity of the driver. So if that person who isn't the keeper or the day-to-day keeper isn't able to name the driver, then the essence of their argument will be that they've given all the information that was within their power to give, or they don't have any information in their power to give, which may lead to the identity of the driver. Because this is a really important distinction, because that's not a statutory defence, it's not a built-in defence where a burden is placed on the defendant, the burden of proof in these cases always remains with the prosecution. So what you end up with is a scenario where the prosecution, and I think I'll be educating a number of road traffic lawyers who watch this, because many of them seem to get this wrong, but the burden of proof when it's any other person always remains with the prosecution to prove beyond reasonable doubt that that person did not give information that was within their power to give that may have led to the identity of the driver. So any other person who says, well, I can't work it out, or there's a choice of people, or I have no information as to who was driving, the burden of proof on them is simply to create a reasonable doubt on the prosecution's case that they did not give information that was within their power to give. Again, it's a really important distinction, and if you have a problem and you're not the keeper or the registered keeper and you think you've given all the information that you could give, or you simply haven't got any information to give, then it's something we'd like to talk to you about, and we can apply the legislation to the specifics of your case. Subsection 5 talks about when a body corporate, so a company, has been accused of this offence, because clearly companies can be the registered keeper of a vehicle and companies can get into trouble and get fined. Companies can't get penalty points because companies can't hold licenses, but there's this nasty little subsection 5 which states that if a body corporate is convicted of failing to provide information, then an individual, a senior individual within the company, can be personally prosecuted if the failure to provide driver information is found to be down to their neglect or their connivance, or with their consent. So I like to think of the example where perhaps a managing director is the only one that drives the particular car in question, and when the request is sent to the company they fail to deal with it. It might be suggested in those particular circumstances, especially if the managing director's got 9 points already, it may be suggested that an individual with the company deliberately neglected to provide the information, or perhaps connived with the MD to not provide the information in order to protect the MD from points, and this little subsection gives the court the power to issue or take proceedings against an individual. Having said that, it's very, very rare for the magistrates to do that, and they'd have to have clear evidence of somebody deliberately scuppering the process in order to go down that route. But that route would lead to an individual within the company being held liable, which could mean that they get points. Then we have the important defence under subsection 7, and effectively what this section talks about is the defence of it not being reasonably practicable for you to respond. So this is the defence that most people argue when they say they didn't receive the request in the first place. So subsection 7b states that you shall not be convicted. Again, it's a statutory defence and the burden is on you to establish this on the balance of probabilities. You shall not be convicted if you can show that it was not reasonably practicable for you to respond, or that you responded as soon as reasonably practicable outside of the 28 days. Now that's the argument that normally applies when people say they didn't receive the request in the first place, and it's a further very important statutory defence. When these notices are sent out, if they're sent out by first class post, then there's an evidential presumption of service, but it's a rebuttable presumption of service, where if you can show that it wasn't received, then you will rebut that presumption. But in essence, from a very common sense point of view, it's about standing up and convincing the magistrates perhaps that you've got a problem with your postal service, and evidence perhaps from a relative who lives in the house with you, that you have an anecdotal problem with your post and that things have gone missing in the past, or that perhaps you've got an address nearby which is very similar where you have to redirect the mail between the two of you. Those sort of circumstances can really help with arguing that it wouldn't have been reasonably practicable to respond to something that you didn't receive in the first place. So that's a very brief guide to section 172. One other thing I think I'll mention is the fact that we've had a lot of inquiries recently where people have said, well, what if I don't sign the section 172 form when I return it? If you didn't sign it, and if you were admitting you were the driver, then the prosecution could never use that confession against you in relation to the offence at the root of it. So it wouldn't constitute a confession as the identity of the driver. But and then there's been a case where the prosecution failed to spot that the person didn't sign the Section 172 form. They pursued them for speeding, and then the court agreed that the confession evidence on the Section 172 was not admissible because it wasn't signed. But what should have happened in that case is that the police or the safety camera partnership should have spotted that the form wasn't signed and should have prosecuted that individual for failing to provide information. So this offence under Section 172. And the reason why they should have prosecuted under 172 is because there's a case called DPP and Broomfield, and in DPP and Broomfield the court stipulated that the information you provide on one of these forms has to be provided in the manner prescribed by the form, and the form requires a signature. So failing to sign the form constitutes an offence of failing to name, which should have put that individual at risk of 6 points. And basically what we're telling people is that individual was very, very lucky that they managed to defend the speeding matter, and that the prosecution didn't actually instigate proceedings for failing to name, which would have been the far more sensible approach. So that's basically a duffer's guide to Section 172. If you have a problem with a Section 172 allegation, then call us on 01626 359 800 and we will happily do a free advice call with you, and we will look at your specifics of your case and apply the law and the relevant court case law. And very often, if you've got a legitimate reason, we'll be able to defend the case, and it's probably one of our most successful areas where we represent clients. So I'm Emma Patterson, I'm the Principal Solicitor at Patterson Law. If you found this useful, then I'm glad, and you might want to have a look for our Facebook page and perhaps follow us on Facebook, because we put useful updates there as well. Thank you for listening.